Hello, all you happy people. As I promised yesterday, here we have the filing that Anthropic is going to be sending up to the Ninth Circuit with all of their arguments. Here in this 109-page PDF, do not worry, we are not going over anywhere near all 109 pages, because we're really just starting off with the official notice and certificate of service. Their actual filing doesn't even start until page 6, and then you've got contents and tables of authorities and everything. We're actually starting on page 13. And there are so many other exhibits and everything at the end. We'll be ending on page, I think it's 36. So we're only doing like 20 pages of this. So this probably will be one of the longer videos, but it won't be that long. It'll be about the typical length. Don't worry about it. We'll get into it. And of course, they'll be reiterating a lot of the points for those of you who haven't been watching my previous coverage of this, but I won't spend too long rehashing that. But they say at the bottom of the page, this petition seeks review of the unprecedented and erroneous certification of possibly the largest copyright class action ever, involving up to 7 million potential claimants whose works span a century of publishing history in a case against the generative AI company Anthropic PBC. And these are the Bartz plaintiffs, just for those of you who are still keeping up. Several other pending putative class actions likewise challenge companies' use of allegedly copyright books to train LLMs. These cases raise important fair use questions that will establish the ground rules for the industry moving forward. Despite the complexities and stakes, the district court here rushed to certify a massive class threatening hundreds of billions of dollars in statutory damages. In a previous video, I did the math on that, and if they had like the biggest amount of damage for every single one of them, it would be over $1 trillion. Anthropic is a startup. It's not that big. It would take them centuries to pay it off. That's ridiculous, and again, the idea is they're just trying to bully them into a settlement. Without any reliable means to identify class members or adjudicate their claims, the certification decision also impermissibly purported to resolve critical merits issues, and it did so by glossing over the individualized issues that would pervade a fair trial. See, the whole idea of a class action lawsuit is the class members are pretty much all the same. The arguments are going to be the same for each of them. The damages are going to be the same for each of them. And of course, like I pointed out in an earlier video, it's really the lawyers who make out from the class actions. Everyone else gets pennies. Well, and the named plaintiffs, they make out to the class members. But if you've got some aspects of your claim that are individualized, you probably don't want to be a member of the class. You want to have your own action you want to take. And so the problem is, what if that's common across the board with members of the class? And that's basically their claim. The district court manifestly erred regarding a fundamental issue of class action law by certifying a copyright class of massive size and complexity, despite the need for individualized inquiries into issues such as ownership, registration, validity, copying, and images. It also downplayed the individualized issues based only on the district judge's judgment from experience of 50 years. That is not the rigorous analysis that Rule 23 requires. This judge knows a lot. He's a good judge. He's been through a lot. This is the Oracle v. Google judge, remember. But that is not rigorous analysis. He also erred by purporting to resolve Anthropic's fair use defense against it at class certification to avoid the individualized issues presented. The court granted Anthropic partial summary judgment based on fair use. Remember, we had that big win where the judge was saying, quintessentially transformative, spectacularly so, etc. But he expressly left open Anthropic's fair use defense for trial based on the so-called pirated copies and entered no judgment against Anthropic. None of that was him saying Anthropic did anything wrong. Yet, the class certification order asserts that Anthropic is liable for infringing plaintiffs' works by downloading books found in certain datasets, regardless of whether they were used for training LLMs. And remember, one of Anthropic's responses is, we're an AI company. That's all we do. Training LLMs is going to be it. We have no other purpose. There's nothing else we could possibly use it for. That is wrong as a matter of copyright law, as another district court recently held, referring to Cadre v. Meta. You can see my earlier reporting on that. The district court's class certification grant may sound the death knell of litigation for Anthropic because the grant would put considerable pressure on it to settle independent of the merits of the plaintiff's claims. And you can see my earlier video where I talked about the problems of just these huge judgments, how you're just bullied into settling. They mention that here. Anthropic faces hundreds of billions of dollars in potential liability, a tremendous amount, particularly for an emerging company. Making matters worse, the court is proceeding at warp speed towards a December 1, 2025 trial, and otherwise has pressed for settlement. And because Anthropic's motion for interlocutory appeal of the court's erroneous summary judgment order, which conflicts with Cadre, rests entirely within the court's discretion. This settlement pressure may ultimately deny Anthropic an appeal of either the merits or class certification absent permission to appeal under Rule 23F. One district court's errors should not be allowed to decide the fate of a transformational Gen AI company like Anthropic, or so heavily influence the future of the Gen AI industry generally. This court can and should intervene now. So they're going over the background of the case. We've gone over this, so I don't need to reiterate it again. So we'll go to page 21 of the PDF file down here at the bottom. No court has ever certified a copyright class of this magnitude, and for good reason. Questions of law or fact common to class members predominate over any questions affecting only individual members. Like I said, that's why you have a class action. But when the discovery and trial process must assess thousands of claims, one claim at a time, individualized issues will predominate. Here, the class members' claims will require millions of fact-specific inquiries into individualized issues, yet the court summarily asserted that this is the classic case for certification. Copyright infringement claims made by disparate rights holders are generally unsuitable for class treatment, and it compounded that error with novel and problematic notice and claims procedures. A plaintiff claiming copyright infringement must prove 1. Ownership of a valid copyright, 2. Copying of constituent elements of the work that are original, and 3. Registration with the Copyright Office. Notably, a registration certificate listing a plaintiff is not definitive evidence of ownership or validity, but creates only a rebuttable presumption. Indeed, because registration certificates often do not reflect subsequent assignments, establishing ownership may require individualized examination of publication agreements, option agreements, and terminations of rights. Accordingly, copyright claims are poor candidates for class action treatment, and for good reason. And this is citing Schneider v. YouTube, which itself quoted a different case against YouTube. So, page 24, each class member would need to make numerous showings under the district court's framework. You need to identify a copyrighted book, present evidence that Anthropic downloaded a file containing more than a de minimis portion of the book's copyrighted text, show that they're a legal or beneficial owner of the copyright, and that it's registered and valid. Anthropic would then be entitled to rebut her prima facie case with evidence obtained in discovery. If the class member establishes liability, she would need to establish the proper amount of damages. But Ninth Circuit looked no further than the name of the case. The named plaintiffs here reflect the individualized and fact-specific nature of the class members' claims. While Andrea Bartz, Charles Graber, and Kirk Wallace Johnson were the three initial named plaintiffs, discovery revealed that Bartz and Johnson were neither legal nor beneficial owners of the copyrights asserted. They didn't even have the copyright over their own books. Plaintiffs thus added Andrea Bartz Incorporated and MJ Plus KJ Incorporated, the loan-out companies that own the asserted works, as named plaintiffs. So they created these companies and gave them the copyrights so they can't sue themselves. Those companies need to be suing. The district court scrutinized each plaintiff's claimed ownership interest, concluding that Bartz and Johnson could not be part of the class. The court explained, for instance, that although the original registration certificate for one of Johnson's works named only Johnson as author and claimant, Johnson had later assigned all ownership interests in that work to other entities. Indeed, because a registration certificate captures only a snapshot in time, it will frequently fail to list entities that later become beneficial or legal owners. Registration certificates are not definitive evidence of ownership, and establishing ownership will require individualized inquiry. And even if a class member shows that Anthropic downloaded a file labeled with the title of a work that has a valid copyright she owns, she must still show that the file contains the text of her work. That will not always be straightforward. LibGen's metadata had missing and erroneous information. Another one is of unknown provenance and contains an incalculable amount of erroneous information. But the district court brushed this aside. He hypothesized that from experience of 50 years, there will be very few competing claimants for the same work. Authors and their publishers have ongoing business relationships, and they'll work out whatever differences, if any, they have over how to divide recovery. We'll just have the trial and then they'll work it out later. But in reality, authors and publishers often litigate the scope of licensing rights. See a whole bunch of cases. Now, the court also improperly placed the burden on Anthropic to disprove infringement, and the district court cited only one inapposite case in Ray Napster. There, 27,000 music publishers, all working with the same licensing agency, sued Napster for operating a platform that impermissibly distributed the publisher's songs. If you've ever worked with this, you know how it goes. You buy a license from UMG, for example, and then you can use any song in that library because you paid the license for it. You use one of those works without a license, it's UMG that comes for you. The court emphasized the agency's up-to-date records on the asserted copyrights, which reduced, if not eliminated, any complications that may arise from adjudicating the individual aspects of the class member's claims. Napster is a far cry from cases like this one, where thousands or millions of unrelated plaintiffs assert distinct claims. Rigorous analysis precludes reliance on a trial by formula, i.e., allowing plaintiffs to establish liability with statistical modeling. The court violated that principle here by relying on its generalized experience to conclude that plaintiffs could prove their claims collectively and that Anthropic's defenses would be uniform. And skipping another few pages because it's review of what we've covered before. Over on page 30 of the PDF, the court failed to recognize that under the framework articulated in its summary judgment order, Anthropic's fair use defense would turn largely on individualized inquiries. To find predominance and certify the class certification order minimizes and even appears to categorically reject Anthropic's fair use defense. And remember, we've covered this before. That's been the real goal of all of these different authors and publishers and everyone else. They want to destroy fair use. And that's why this is such a threat. That's why it's a threat to you and me, and that's why I keep lamenting that I'm the only YouTuber covering this. I'm the only one letting you know about this. Use the donate links below if you like that. The apparent use of a class certification order to resolve critical merits issues contravenes Supreme Court precedent. Both errors justify immediate review. Throughout this case, Anthropic has argued that it copied books data, including by downloading datasets from LibGen and Plimi, I don't know how to pronounce that. You notice I've been avoiding saying that until now, to develop Claude, which is a transformative new product that is nothing like plaintiff's books. Anthropic moved for summary judgment on that basis. The district court then sua sponte bifurcated Anthropic's LLM training on copyrighted books, which it deemed fair use, from Anthropic's downloading of those books. And by the way, just so you know, sua sponte means he did it on his own. No one prompted him to do this. Plaintiffs didn't ask him to do that. They didn't argue for it. Anthropic never got a chance to argue against it. Judge just did it. Sua sponte. That's what that means. The record reviewed in plaintiff's favor shows that Anthropic also downloaded books for a different use to create a central library where books would be stored. And I don't normally read out the footnotes, but this one's important, so we're going down here to the bottom. Plaintiffs never argued that such a separate use existed, and the court misconstrued the record. Anthropic downloaded books only to develop LLMs, not to create a general-purpose library. Because that's all they do as a company. They make LLMs. That's the only thing they're going to do with it. As noted, the district court in Cadre granted summary judgment to Meta on the basis that copying for the ultimate purpose of training, including downloading from some of the same pirate sites, is fair. Alright then, back up to the top of the page. Thus, the court reserved for trial whether Anthropic in fact had a separate central library use for some or all downloaded works, and if not, whether Anthropic's use of those works for LLM development rendered its downloading fair. The court indicated that the fair use inquiry would require examining how quickly Anthropic used a work for training, whether and for how long Anthropic retained the work, and the purpose of retention. Because those facts vary from work to work, allowing trial on the novel central library theory raised a host of individualized factual issues. And again, that's the theory that the judge just kind of made up. The class certification order brushes away those issues, stating that, to the extent fair use were to recur as an issue at trial, there is no reason to believe that it would not be susceptible to treatment by common evidence and common methods. The court cited no support for such unidentified common evidence and common methods. The court thus manifestly erred. Although the summary judgment order recognizes Anthropic's right to present its fair use defense at trial, the class certification order seems to eliminate that defense. It declares that Anthropic is liable for all pirated copies regardless of whether they were used for training and regardless of whether another copy of the book was bought and scanned. To the extent the court purported to resolve fair use at class certification, it manifestly erred. And they go back to the Google Books case, one we've talked about a lot. The Second Circuit observed that resolving the fair use issue would perhaps moot its analysis of many class certification issues. It therefore vacated a class certification order and held the issue of class certification in abeyance until resolution of fair use. This court should allow the Second Circuit's approach by, at minimum, granting review and vacating the class certification order so that appellate review of the district court's erroneous fair use ruling can preclude any class certification decision. And down here at the bottom, the court certified a class with approximately 7 million works, and per work statutory damages can range from $200 for innocent infringement to $150,000 for willful infringement. There is thus a liability risk of hundreds of billions of dollars. A damages award in that range would be devastating for Anthropic, or indeed almost any company. Although Anthropic has raised a total of $15 billion, and they love throwing that around on the socials, don't they? Oh, they got billions, I can afford it. They got billions, I can afford it. No, it operates at a loss, i.e., it is years from generating any profits. It currently expects to generate no more than $5 billion in revenue in 2025 and to operate at a loss of billions of dollars this year. And even if they put all of their total revenue toward it, it would still take them centuries to pay off. If Anthropic must wait to appeal the district court's erroneous order until after trial, the potential total damages may make it impossible to post an appeal bond. Because the appeal bond is a portion of the total damages. You have a right to an appeal. You have a right to at least a 3-judge circuit appeal. Always. Now, if you want to go from there for an en banc appeal, they don't have to do that. And then you can appeal to the Supreme Court. They don't have to take it. But that first 3-judge panel in the circuit court, that is always your right. They just want you to post a bond, which normally is reasonable. But what happens if the judgment is so big that that bond is more than you can ever possibly pay? That's a problem, and that's one way they bully you into settling. although plaintiffs filed suit long after other similar copyright class actions. And remember, we've talked about before how much further along Cadre v. Meta is. I think we still don't have a trial date in Cadre v. Meta. Looking at the schedules, there's like this thing and that on this date and that date. Not a trial date yet. But in this case, the court expedited this case beyond the parties' proposals to be the first to class certification and trial by a wide margin. December 1st. None of the other cases are going that fast. So, Ninth Circuit, what's the damn rush? The court also set a compressed schedule for notice that, among other things, gives Anthropic little time to challenge plaintiffs' proposed class list. And the court has repeatedly made clear its views that Anthropic is liable and guilty of piracy and stealing before trial has even occurred. These actions have exacerbated the pressure for Anthropic to settle regardless of the merits. Anthropic's fair use defense is meritorious, and had it been before Judge Chabria, Anthropic would have prevailed on summary judgment. Even though, as we pointed out, Chabria was kind of splitting the baby, he couldn't split the baby enough to completely get rid of fair use. But Anthropic's pending Section 1292B motion rests entirely within the discretion of the same district court that has accelerated this case to hold a trial before taking in active status. Absent a stay and Rule 23F review, Anthropic may have no path to appeal the rejection of its fair use defense. Losing its fair use defense would be horrible. Losing its right to appeal it would be devastating. The death knell doctrine exists to address situations exactly like this one. This is pretty much a textbook death knell case. And courts of appeals routinely grant 23F petitions in similar circumstances. And although the stakes for Anthropic alone could not be higher, the stakes of this case are higher still because the district court's framework threatens not only the fate of Anthropic, one of the industry's smaller and newer companies, but that of the Gen AI industry more broadly. One court's defective rulings should not be permitted to alter the course of this transformative technology. Yeah, so that's what's going up to the Ninth Circuit. Hopefully they take it. They don't have to take an interlocutory appeal, but they've really made a case where they should. But it'll be interesting to see how that gets filed and what the Bartz plaintiff's response is. But yeah, this is classic textbook fair use. The judge himself said that AI training is quintessentially transformative, the most transformative any of us are likely to see in our lifetimes. If they can stop this blatantly obvious fair use, then the rest of us are in trouble. And that's just all there is to it. So I will keep you posted on that. And if you like that, please keep me doing it by going to donate.bogosity.tv, giving whatever you can, large or small. Leave a comment, like, subscribe, hit the bell, and share this video. Share these. They are not getting up in the YouTube algorithms. This is going to depend on you sharing it to as many people as you can to try and knock down all of those who are spewing falsehoods on social media. Because I gotta tell you, they're all part of a pretty organized effort. Well, we have to be too. We can't just be one lone voice shouting in the breeze. We have to, each one of us, do what we can to get this out there. Thank you so very much for watching. Until next time, stay strong and be free.